So good morning, everyone, and welcome back to our weekly webinar series. It's always a pleasure to connect with all our participants, and we really appreciate all the people who join us every week. Today's one is a special one, and it's especially important in light of the idea that it affects everyone. And if we talk about the proposed changes and discussion on that, we were able to see a lot of changes that will also affect processes that are going on currently, and also bring a lot of comfort to the stakeholders in the process, because many pending issues have been resolved in the proposed amendments to IBC. So let's not waste more time. We have a lot to do. Over to Anil, sir.
Thank you, Ankit. So welcome to all participants into our 42nd episode of webinar series from AAA Group. So the session today is on a very, very important subject. This is the proposed amendment in the IBC, which is notified by, which is available on the public domain by way of a notice from Ministry of Corporate Affairs on 18th of January 2023, where the Ministry of Corporate Affairs has asked suggestions, comments, and on the proposed amendment. Subject is very large. The time should not be wasted, so we would not like to have two sessions because everyone is interested in knowing what exactly are the amendments and what kind of suggestions we should give. So let me share my screen. It will take 1 minute. So this is my PPT. Yes. So the proposed changes to Insolvency and Bankruptcy Code 2016, which was by way of a notice by Ministry of Corporate Affairs. It was on the public domain on 18th January, and the suggestions and the comments are invited from public at large to be submitted latest by 7th of February 2023. There is a format of, there is a link in this notice which can be clicked, and this link is also available on IBBI website. Anyone who can actually suggest something, it will be really beneficial to the entire stakeholders in IBC. I would say that there are some amendments which are already there through the regulations. However, maybe the central government thought that it should actually come through the parliament. So therefore, this particular proposal to amend IBC, in fact, I could see there are 30–40% of the amendments which are proposed in this are already somehow being implemented by way of regulations, which has been already notified by the regulator IBBI. I think we can simply go ahead. These are some of the basic headings that they have used. Use of technology in the IBC ecosystem, admission of CIRP applications, primarily faster admission of CIRP applications, streamlining the insolvency resolution process, recasting the liquidation process, role of service providers and other stakeholders. These are the major headings. We'll start with the use of technology in the ecosystem. So the thought process which is going on is that all the institutions like MCA, the adjudicating authority, IBBI, information utility, all the service providers like the valuers and the IPA and the IPs, they actually are adopting on and operating on separate technological platforms. IPAs are using separate technology platforms. IBBI is using separate. So therefore, they are actually trying to collate all and provide one platform where everyone will submit their information returns, and that can be that would be available to all stakeholders like IBBI and adjudicating authority and Ministry of Corporate Affairs, IPA, and also the insolvency professionals, and also in some of the stakeholders like the creditors. That kind of electronic platform is being thought. It's a welcome suggestion, and We also would say that the duplicacy of submission of the information to IPA and to IBBI, that should be avoided. Frequency of the returns, which is related to the starting of the case, that also can be somehow linked to some period in the calendar. Because today, in case somebody is having 7 cases in his name, so maybe there is a date, there is a deadline every day for each case because of the CIRP 1 to CIRP 8 and also IP 1. All these forms are required to be filed based on the some time lines and some event based. So therefore, it is suggested that some kind of common timelines may be provided for submission of all this information, maybe monthly. That will be really beneficial and user friendly. So it is proposed that some automatic processes would be used, like the filing of application to adjudicating authority, delivery of notices also would be automatic, enabling interaction of the stakeholders, storage of records, underlying and undergoing the process, incentivizing the participation of other market players in the IB system. So I think this will have a better oversight, and this is definitely a welcome move. The next is admission of CIRP application, where the everyone is trying to somehow the admission process to be fastened, so that when a financial creditor or an operational creditor decides to invoke insolvency law and file an application under section 7 or 9, there should not be any kind of adjudication. It should be a very, very summary kind of process that everyone is endeavoring, because that gives time to the corporate debtor to siphon off and to cause loss to the stakeholders. In fact, section 215 subsection 2 of the code already provides this requirement that all the financial creditors need to submit their financial information to information utility, and in the case of default, that record can be presented to the adjudicating authority to determine whether the default has taken place or not. So this was, however, directory for the operational creditor, but it was mandatory for the financial creditor. So in this particular proposal, the financial information is submitted. There is no requirement for the CD or the debtor to respond to such information. So now the changes are being made so that the debtor also is required to respond to the information which is submitted by the financial creditors. Also, the section 214 of the code, subsection E, creates an obligation for the information utility to get information authenticated by all concerned parties before storing such information. So presently under section 7 and 9, in addition to the records of default available with the IU, other evidences can also be submitted to establish that default has occurred. So this process needs to be strengthened, and the endeavor of these amendments seems like that let the evidence of debt and default and the dispute be ascertained at information utility level, and the time of the adjudicating authority would be saved. So the amendments are proposed in such a manner that the relevant information should be submitted and regarding the default and dispute, and let that be handled by information utilities. According to my understanding, that also may take time. And now, since the law is clear, it would be very clear to the corporate debtors or the defaulters that they have to report a dispute whenever anyone submits an information to financial. When anyone submits information to IU, any financial information, most of the corporate debtors would be disputing that information. So the dispute will actually shift from adjudicating authority to IU. And after this amendment, suddenly the importance of IU would actually be increased substantially, and everyone would be it will be mandatory for everyone to know the provisions of IU, so that they if there is any financial information submitted for any debt or any default or any dispute, that should be reverted by the corporate debtors. That kind of training would be required. Otherwise, the default would be proved and the adjudicating authority would not listen to the corporate debtor, and the adjudicating authority will simply rely on the IU. However, there are possibilities of further litigation regarding the authentication of the information of default by the IU, regarding the process adopted by the uh, IU. So these kind of litigation is expected, and in this case, the IU has also been given IU has also been given a kind of responsibility to authenticate the information, to authenticate the information, to authenticate the information. See,
There are
just
two three
yes, please.
things here. Let me add to this. So the idea now will be that one, already the FCs were obligated to report a debt to the IU, and the IU was sending out confirmation emails to the CD. Now, earlier, there was no provision for those submissions or those mailers to the CD to be taken seriously. However, there was a change recently where if the IU sends out two reminders to the CD with respect to a debt, then the debt becomes a concrete, or rather, it is established that since the CD has not replied or not, it will be presumed that the debt is genuine. So that was happening already. Now, what they have added is that with respect to the OCs right now, they have said that where the OC intends to apply to the AA, he will also be obligated to file his default or file that debt to the IU, and the IU will also work on sending out the emailers, or rather the confirmation mails to the CD, seeking any dispute, if any, from the CD and the relevant attachments paperwork. So IU is becoming more important, but then when we go forward and read this part, that it will be mandatory for financial creditors as well as OCs to also talk about whether the IU has, whether the record of the default is available in the IU. In case the IU says that yes, the default is there, then that will be deemed as the concrete proof that there has been a default. In case the IU still does not have the information with respect to the default, or there is a dispute pending at IU, then the rights will still be available with the adjudicating authority to look into the existence of a dispute and then take action on the proposal, or rather the filing of the application. This was my understanding of how the things will work now practically.
Yes, I believe all of us, all professionals will see the complete operations of IU, complete regulations of IU. We would all, it will be required to know the process of authentication by the IU. So it will be a kind of knowledge that everyone would like to acquire, how to uh, safeguard the companies from the information or any kind of incorrect information which is submitted to IU. So most of the corporate debtors, they would train their uh, accounts department, finance department to understand this part. Then we also, there is a kind of exception that in case information is not available on IU, and in some limited cases, genuine reasons can be shown and may be considered, uh, other evidences also may be considered. Just a minute, Ankit. So I think now the other a situation which is mandatory to admit an application filed under Section 7 where occurrence of default is established. I think this is the present framework where this word may has been used, and that is where the word may, in any case, the impact of Vidarbha Industries Power Limited versus Axis Bank. So this actually is somehow it is proposed to be diluted. And this recent judgment, there is a confusion regarding the scope of adjudicating authority and the discretion of the adjudicating authority regarding admission of an application or rejection. So in this case, it is now proposed that the powers of the adjudicating authority is limited to determination of default, and the provisions of Section 7 does not require the adjudicating authority to consider other factors or circumstances regarding the inability of the corporate debtor to repay its debts. Regarding the timeline of 14 days, which is provided in Section 7, it has been interpreted that this particular timeline is, it was interpreted that it is only applicable to ascertainment of default, and it is not applicable to admittance or rejection of the application, because the wording used there in Section 7 was that within 14 days, the adjudicating authority is supposed to ascertain the default. But that's also now being clarified that within 14 days, it is proposed that some suitable amendments will be made so that this applicability of 14 days is for admission or rejection of the application and not only for ascertainment of default. So these provisions are welcome provisions. I think the most important part is still the capacity of the adjudicating authority. They are overburdened, they are overbusy. And secondly, this IU scenario which is being created, I think that actually can work, that can help to some extent. But to my understanding, some kind of dispute would be created by most of the corporate debtors when any financial information is submitted to IU. So IU will become very, very powerful in case the IU says that it is disputed. And if the IU says that it is not disputed, that actually will decide the outcome of an application under Section 7. So that's something which is considered to be shifting of power from adjudicating authority to information utility. It is like Vidarbha, as I said, that the impact of Vidarbha is being diluted with this proposal. I think that's welcome, because otherwise we have seen that the kind of arguments that most of the corporate debtors are coming up now, when a application under Section 7 is submitted, they have started saying that it is a temporary fund flow problem. The company has better prospects. The company is being taken over by someone. The company is also pursuing one-time settlement, which is a better solution. The company is also applied for the restructuring, which is a better solution. So all these kind of arguments actually have gone is started in the NCLT for application under Section 7, but that actually would stop, and the NCLT will be focused on the determination of default and admission or rejection of the application. So Ankit, as we said, the proposed amendment we've already discussed for CIRP admission.
This one is important. So where it says that 14 days, the earlier judgment which had differentiated between the idea that that the AA's decision to admit or reject the application was understood that the 14 days do not apply to that, but it was only applicable to ascertainment of default. So this has also been amended, reasserting that the timeline of 14 days is actually with respect to the admittance or rejection of the application under Section 7.5.
Yeah.
So that's an important change. So because that's a big pain point that the applications don't get admitted for months and years sometimes.
So I think this is one small amendment which actually will have a good impact, that under Section 10 applications which are submitted by the promoters or key managerial personnel, in those applications, the interim resolution professionals are not required to be proposed, because in most cases, the IRP needs to have the trust of the creditors. So any IRP which is proposed by the promoters cannot
So random selection is better than the selection made
random
by the
selection is
CD, and
better.
that's a good thought.
Yeah, although it is mentioned that it will be appointed by the adjudicating authority on the recommendations of IBBI. That means that it will be appointed from the IBBI panel.
Yeah.
So that's a good amendment. There is no suggestions and no comments on this. Then I think the other, which is a very important proposal, is to empower the adjudicating authority to impose penalties for violation of the code. So presently, under Section 235 capital A, it provides for punishments to be imposed for contravention, and the punishment which is provided in that Section 235 capital A is for an amount of ₹1 lakh or 2 crores. That's the amount which is mentioned there. However, the notice which has been released by the Ministry of Corporate Affairs, it actually says that these penalties can only be imposed by a special court established under the Companies Act, and that actually would be imposed through criminal proceedings. I somehow could not find that section, or I could not find that provision in the code where it is written that Section 235 capital A would only be a kind of, it will be a criminal proceedings. However, this clarification is still a welcome clarification that the adjudicating authority would be empowered to impose penalties for various reasons. One reason is maliciously instituted proceedings before the adjudicating authority to delay the conduct of the process. And these kind of proceedings are initiated with no reasonable prospects of success, and it's basically targeted at delaying the process. And these are the proceedings with insufficient evidences submitted without any purpose to determine the actual issues. Now, these proceedings take up substantial time, which can be utilized for other things. And Section 65 always is already there in the code, which says that, which provides for a penalty against fraudulent or malicious initiation of admission proceedings. However, no penalty is imposed on other proceedings filed before the adjudicating authority. The Section 65 is only and only applicable to malicious initiation, malicious applications under Section 7 or 9, but it is not applicable to other kind of proceedings. And the second impact, which is a very important impact, is that now what we see in the process in most of the CIRPs, that we see that first of all, the promoters will not provide information about the assets of the company. They will not provide information about the fraudulent transactions, undervalued transactions, or even they would not provide
Actually, books of accounts. Yeah,
books of account. They will not provide the access to books of account. In the process, the registered valuers will have no option other than saying that the value is negligible, because if the documents are provided for all claims of the company, if the documents are provided for all the litigations on the asset side of the company, on the contingent asset side of the company, in case the documents are provided for all the arbitration on the asset side of the company, then the valuation would be higher, and the registered valuer will actually would place a value which is higher. And now the process which is going on in the practice is that the promoters will not provide information. A Section 19 subsection 2 application will be filed by the IRP, RP, and the information will still not come. Information will come by the end of the CIRP. Till that time, the valuers will have concluded their valuation report, and then the promoters will submit their resolution plan either directly or indirectly, and they will try to acquire the company at a very low price, and this will cause much loss to the stakeholders. Now, there are two things that this particular section will enforce. One, that the penalties can be imposed on the promoters for not providing the information, and also Section 29A, Section 29 capital A is being amended, where the in case the promoters are not cooperating, then they would not be eligible promoters to participate into the resolution process. So now Section 235A is proposed to be converted into a civil penalty, and it is also amended to empower the adjudicating authority to impose penalties where a person fails to comply with the provisions of the rules and regulation. Our only apprehension is that this should not be applicable to imposing penalties on the insolvency professionals who are engaged as IRP, RP, or the liquidator, because that power should continue to be with the IBBI. Otherwise, the IBBI also and the adjudicating authority also. But the only suggestion that we would like to give that this section 235A, the powers of the adjudicating authority would not be applicable for imposing penalties on the insolvency professionals. Now, this particular power with the adjudicating authority will assure three things. One, that this will actually discourage initiation of some fallacious proceedings with the intent of delaying the process, and any kind of frivolous and vexatious applications would also be prohibited. The minimum penalty which has been proposed in this section 235 capital A is rupees 1 lakh per day. 1 lakh per day of non-compliance, and which may extend to 3 times the loss caused or unlawful gains, whichever is higher. Now, this has been linked with the penalty and the loss caused or unlawful gain achieved. I think this is a welcome, very welcome move. The only thing is that this is not applicable to the insolvency professionals, and the section 29A also is proposed to be amended, that if the promoters are not complying with their obligations, they actually first they would be imposed with penalties, and then they would be ineligible under section 29A, and the adjudicating authority will debar them from being a resolution applicant and submitting a resolution plan. So I think this is the only suggestion that we can give, that the adjudicating authority, while exercising this power, shall be required to consider the conduct of the promoter in the relevant CIRP and the gravity of the contraventions committed. So, Ankit, this is again a good scenario. Anything that you would like to add on this section 235 capital A and also the amendment to section 29 capital A, giving powers to adjudicating authority?
So I think 235A, if you read the section, it only talks about punishment where no specific penalty or punishment is provided. That is the current state of affairs. So I believe that
the penalty that they have provided in section 235, in fact, I read this 235A. So I saw that this
235A is already there, which only talks about punishment.
Not less than 1 lakh rupees, but which may extend to 2 crores. But if any person contravenes any provisions of this code or the rules of regulation, for which no punishment or penalty is provided in this code.
So what I'm trying to say is that there is a specific penalty or punishment provided for an insolvency professional who is not following the regulation. So yeah, he naturally does not come under this section. This will, I think they will amend it in a way that it targets maybe a part of the 234A, revised 234A targets the ex-management which is not cooperating. And the interesting fact is 1 lakh rupees per day is the cost that they have talked about here, which is huge, and also 3 times of the loss that somebody else has incurred for causing delay in the process.
But presently, when we think that section 19 subsection 2 applications are not actually reaching to a favorable conditions,
this will give teeth. This will give teeth. Yeah, this will give teeth to the NCA.
The adjudicating authority, either the promoters will cooperate or they will actually face this kind of because the loss which actually is being caused by non-providing information, that is substantial, and any kind of penalty can be imposed on the promoters on such behavior. So then in case the penalties are not paid, then it will be a contempt of court, and the information which presently is coming in the 9th month, when everything is concluded, the valuation is done, that actually will start coming when it is required. Moving forward, on the next subject, which is streamlining the insolvency resolution process and the rethinking of the fast track corporate insolvency resolution process. To my understanding, the only 2 things that they have now but they are introducing fast track insolvency resolution process for the understanding of the our listeners. So we already have a corporate insolvency resolution process, CIRP. We also have the pre-packaged insolvency resolution process, which is PPIRP. We also have the personal insolvency resolution process or individual insolvency resolution process, which is the PIRP or IIRP. And now we have the FIRP, so fast track insolvency resolution processes. So we have
But it has
CIRP.
been it has been here, but it is unused, lies
Yeah.
unused.
So now we actually are thinking of having CIRP, PPIRP, PIRP, IIRP, and this FIRP. So these kind of resolution processes are available. I hope some better results will come with this fast track. However, the only thing that significant I could see in FIRP is the non-availability of moratorium to the corporate debtor. If the pre-packaged insolvency resolution process has actually also been amended. In the pre-packaged insolvency resolution process, if we say that the moratorium is something which actually the COC will decide whether the moratorium, or the financial creditors will decide whether the moratorium would be available or not, I think this FIRP and the PPIRP would still be preferred. Because see, like according to my understanding and my interaction with the financial creditors, they are not using PPIRP only because of the moratorium. They think that once we use PPIRP, then the promoters will go under moratorium. So in this FIRP also, what the proposal says that in this case, even the moratorium would be the discretion of the committee of creditors. So therefore, there is some kind of redesigning is being done, and it is only and only somehow possible where the financial creditors have taken direct or indirect control over the corporate debtor, allowing they can allow the proceedings. So this is also something. The proposals in this case is that the unrelated financial creditors, of course, the COC that we are talking about COC only. Unrelated financial creditor is the COC only. They will select and approve a resolution plan through an informal out of the court process and involve the adjudicating authority only at its final approval or a moratorium. So there are two situations when the adjudicating authority would be involved. One, in case the COC decides to seek moratorium, and also for the final approval of the resolution plan. Insolvency resolution through this procedure will be available for the series with such asset size as may be notified. So the Ministry of Corporate Affairs will come up.
So traditionally, this has always been for a very, very small entity. And even if you look at the current regulations, I think it's a very, very small number. So many companies don't even fit into that threshold to go for a fast track CIRP. So I think the idea now is that the FIRP will become a out of court one-time settlement approval kind of a system, where if moratorium is required, then moratorium can be obtained from AA through an order. And then alternatively, of course, the final approval can get the stamp of the AA with respect to any restructuring or any out of court settlement process, which can allow the company to run and the creditors to get whatever they can get through a legal court process. But at the same time, PIRP, the changes are different. The changes are that one, they have kind of expanded that beyond MSMEs to take into account other companies also, which might be notified. So they might again come with some kind of a criteria where PIRP can work. And then they have removed the whole idea that PIRP can be converted into a full-fledged CIRP or liquidation, or PIRP can then also, they have also reduced or removed the system where PPIRP could have been converted into a CIRP process, liquidation process, or where the allegation of fraud could have come in. So they have also amended that.
So in brief, in case we have to say what exactly FIRP is, they are proposing that the present financial limits that would be changed so that it starts getting more response from the market. Number two, it is more suitable to those companies where the financial creditors have already taken some kind of control and custody. Number three, an insolvency professional is also required in this case. Number four, the adjudicating authority is only involved at the stage of final approval, or in case the COC needs a moratorium. 66% voting share is in any case required, so that's not being changed. The special regulations will be made, and the modified regulations will be made by IBBI. Then only we will actually come to know the exact process. So this is the fast track insolvency resolution process. So we have to see two things before we actually start commenting on the success of this. One is the financial limits, which will be given by the Ministry of Corporate Affairs. Second is the regulations, which will be given by the IBBI. Then only we will see whether it will be usable or not. However, what I understand that what are those companies where the custody and control has been taken, I think the bank can take control and custody under SARFAESI Act, and then the bank can find a buyer who actually would like to take over the company as a resolution process, so that the company gets transferred to the buyer. Presently, under SARFAESI Act, the company is not possible to get transferred because the SARFAESI Act is only applicable to assets. Now, in case the assets are taken over, under SARFAESI by the bank can immediately find a buyer who is interested in taking over the company and invoke FIRP and can apply for the resolution plan to adjudicating authority. So in this case, even the moratorium is not required. And in case the moratorium bank feels that there are some creditors, they are still pursuing a different path, then the bank can also apply for the moratorium. So this is the utilization that I see. However, it all depends upon the time, the financial limits, and also the regulations. And then coming back to the PPIRP, I'm saying that there are three broader amendments which are proposed, and since it has not seen success so far, the PPIRP, the framework, it is proposed that it should not be restricted to MSME only. It can even go to a broader range of corporate debtors. That is the recommendation. And also, there are two things which are these are section 54A to E is being amended, and then 54(3) is also being amended, and section 54C(3)(C) is also being amended. Now, what are these three situations?
Three large changes are: one, they are reducing 66% to 51% voting requirement. So effectively, more proposals will go through in case the majority of the financial creditors are saying yes to the proposal. So earlier it was 66% both for appointment of the RP as well as initiation of the PPIRP before going to NCLT with the PPIRP proposal. But now it will be 51%, allowing more companies to seek or get approval from their FCs and then go to NCLT to get the PPIRP process forwarded. The second thing is that they have removed the requirement for declaration of existence of any avoidance transactions, because I think this they felt can be always be processed later, because this was also causing maybe some kind of a the companies were not giving this declaration because they maybe felt that this declaration can put them on the wrong foot, because the whole process can be disputed in case in future there's an avoidance transaction that is revealed. And lastly, the third major change is that the option for financial creditors for change of management or conversion of CIRP or liquidation have been removed now. So PPIRP, they say, will continue, and in case the financial creditors don't approve the resolution plan, which they still have to approve with 66% votes, then the PPIRP will finish, and then all options are open to the FCs. That's the basically big change.
I think these are significant changes. The only one more change, in case it can be recommended, then it will be used by the most of the financial creditors. The moratorium also should be when the financial creditors make the application for using PPIRP, they also should opt, like in the case of FIRP, in this case also the moratorium, whether applicable or not, whether required or not, that should also be the discretion of the financial creditor and not the corporate debtor. Had this also been added into this, then I think this will be a very, very short and very, very cost-effective process. And since the all this section 50, 54J, 54O, 54N, all are omitted. So the only thing is, whenever the financial creditors are not comfortable, they will simply terminate pre-packaged insolvency resolution process, and the matter ends. And the company is continuing with the promoters, and the financial creditors may have other options. They will not be suffered with the moratorium because of the moratorium. So this is like the only thing that I would recommend for the success of it, as the government is thinking about the moratorium at the discretion of financial creditors. Similarly, in the case of PPIRP also, moratorium at the discretion of financial creditor, and all these deletions and all these changes definitely will work for PPIRP. Coming to the improvements outcome in the real estate cases, there are lot many cases, and there are different interests. The interests of the home buyers are separate. Interests of the secured financial creditors are different, and interest of the landowners are different. So therefore, some various experiments were being done, and one of the experiments which was done by the reverse CIRP and the project-wise resolution. However, the scenario that now it is being proposed, it is proposed like when real estate companies, the default can be restricted to the project which is in default. Presently, this is only through the judicial pronouncements, but there is no such provision in the law. So not many bench are endeavoring this kind of resolution. But now, in case they will bring it to the law that only those projects which are under stress should go for insolvency resolution, that actually would be welcome. But then some more procedural regulations may be required, that how to manage the company, who will manage the bank account, and how the common loan will be handled, how the transfer of funds from this project to the other projects would be handled. So these are some of the issues which are still unanswered in these proposals, where we should recommend it. But when we think about the project-wise insolvency, there are issues. The issues are like, what about the common borrowing, which are taken in the name of the company, but it is applied to this project? How the claimants will file the claims if they do not know their money has been used for which project? Then the amount which is diverted from this project to other projects, that also how to handle this? Which bank account will be used by the RP, and the other bank accounts will be used by the promoters? So these are, and how the, so these are some of the practical issues. I think that also needs to be handled. So therefore, the resolution for a process, resolution for a project is definitely a welcome move. So Ankit, you can also see, but the one important amendment which is there, like the section 28 would be amended, because the presently section 28 provides that the RP would not have any power to transfer the ownership of an asset which is mortgaged or pledged to financial institutions. The RP has only power to sell some of the assets which are unencumbered. However, in this case, the specific powers are being given to RP, that if the project is getting completed during CIRP, the RP has all the powers to transfer the ownership or execute the sale deed or conveyance deed in favor of the allottees after taking money from them. This is a very, very important, but however, some regulations are required. Otherwise, what I understand is the insolvency law would be used by the promoters to circumvent the financial creditors, secured financial creditors' obligations, and this will be used only to make the home buyers happy, so that they don't go to RERA or they don't go to consumer courts, and the builders will try to bring in the CIRP and try to transfer the titles through the RP to the home buyers. This is some kind of, but there has to be some checks and balances that such transfers are, if given to the home buyers, that will only be given after the project is completed and not before that or after that particular property is completed. Yes, Ankit, you want to add something on this real estate?
I think like the idea that the thing that you shared, that if the home buyers are a majority in the financial creditors or in the COC, then they can choose to get this allotment done. I think we can't have new allottees. I think the part
No,
that I
only
have
new
read,
lot.
that
Only,
it can only be for existing allottees. So in case somebody is an existing allottee and his flat is almost complete, and he can be given possession of that plot or that flat or that ownership, then he can be given that. So but yes, there are these big disputes with respect to which are actually subject to actual verification, with respect to how a person has become an allottee. Has he simply got an allotment on a backdated basis? All those problems are here, but those are factual issues or practical issues which can be countered with verification, and that they can be resolved.
I think going forward, like these are some of the amendments which are already there in the regulations. In fact, on 16th of September 2022, some regulations were inserted in section in regulation 37, a regulation sub-regulation M was also inserted, and also in regulation 36 capital B, a regulation 6A was inserted, and that was similar to these amendments. So I think
So
the
we
amendments
can quickly go through these. Yes,
yes.
so this one is actually with respect to the idea that one can't COC can't approve more than 2 resolution plans, but then there was a change in the regulation which permitted some assets to be sold while the CD is transferred as a going concern through a resolution plan. This can, I think, as per regulations, present regulations, happen if the first EOI fails. Then the second EOI onwards, you can have this clause that certain assets can be sold separately. I think this is helpful where maybe the company is a going concern, but it has a large asset which will have a value in the market as a separate asset, and maybe the resolution plan, the person is submitting the resolution plan may not be wanting to acquire that large asset. So there, now they have said that as long as there is one resolution plan which talks about the transfer of the CD or the continuity of the CD as a going concern, then the other plans can actually then that is okay, as long as the other assets are then transferred.
So these are all available. Like what now we can see the what are the proposed amendment is that the individual the COC may approve that individual or collective assets of the corporate debtor may be resolved in one or more resolution plans. I mean, as far the resolutions are concerned, resolution says that first the company as a whole will be tried, and then later on the company actually can be bifurcated, and then it can be tried in a bifurcated manner. So now the company can have one or more two resolution plan. It is also provided in the proposed amendments that if one resolution plan is approved, the CIRP will continue till the entire company. Somebody will have to be there who actually will take over the company as a going concern. If one resolution plan is approved, and that kind of demerger or restructuring also will be proposed in the same resolution plan. So the scenario is that if one particular resolution plan is received and it is approved by the committee of creditors, by the entire committee of creditors, it is not simply the lenders of that part of the project. So by the entire COC, if the resolution plan is approved, it will go to an NCLT. NCLT may approve that. However, the CIRP will continue. It is also a condition in the proposed amendment that at least one person would be there to take over the entire company as a going concern, so that the company would not be left with the RP. So there can be one project, one resolution plan already approved. Number two, project means factory also, business also. And second resolution plan also is approved. But there has to be one final resolution plan which actually where the company is being transferred. So this is what is the proposal in this. So I think this is also welcome. But yes, in all these amendments later on, the this amendment will be followed by some changes in the regulations also, because then only this will be implemented fruitfully. I think this is also the separation of resolution plan and the distribution of proceeds, as per our experience when we uh, talk about the various IAs which are being filed in CIRP. And in case we see the nature of IAs, some IAs are basically for the belated claims. Some IAs are that the resolution professional has not accepted their claims accurately. They have some grievances on the acceptance of claim. Then there are some kind of IAs on the verification of the security interest. So all these are basically having impact on the distribution of proceeds. So none of these IAs are having any impact on the approval of the resolution plan and handing over the business of the company to the successful resolution applicant. So this is well thought that why should we restrict, because see the presently why there is a shortage of resolution applicants in the market, because the resolution applicant is actually going and entering into an uncertainty when the resolution plan will be approved by the committee of creditors, when it will be approved by the NCLT. That is a completely uncertain scenario. So therefore, the resolution applicants are coming with a lot of risk factor. So that is actually diminishing the value for the creditors. So in this case, in case the distribution of proceeds is separated from the approval of the resolution plan, that's a very, very like important amendment. So the resolution plan is approved and all the requirements under section 30 subsection 2 as far as the resolution plan is concerned is met with, then the resolution plan can be approved. Now the amendment says the segregating the concept of the resolution plan from the manner of distribution. That's one thing. The COC definitely will be required to understand the basic requirements, mandatory clauses of the resolution plan, whether the resolution plan is compliant to all laws of the land. That is definitely is the duty of the COC, and also the NCLT will verify it, and the resolution plan can be approved. So all the disputes regarding inaccurate distribution, claims not admitted, belated claim, security interest not accepted, not admitted, the dissenting creditors are not getting their dues, the value of the property of the value of the liquidation value of the dissenting creditors, all these disputes can stay and can it can actually, the distribution of the proceeds can happen only when all these disputes are resolved. So I think this will solve many problems, and the market will become a kind of a very hot market for resolution applicants, because they would be almost certain that they would get the company within a stipulated period. The distribution can be separate, and the adjudication of the distribution of proceeds can also be separate. So this is what is the kind of Ankit, any comments from your side?
I think this is perfectly okay. We should go forward.
Yeah, but then one thing that they have proposed in this distribution of proceeds process. Now they are saying that the distribution in a resolution plan can be made in this manner, that there is an equitable scheme of distribution in the resolution plan. So what is the equitable distribution? They are saying that the secured creditor will receive the proceeds from the, they will be receiving the proceeds based on the liquidation value of the company. And now, for example, what is proposed here is that in case a resolution plan is received for 500 crore and the liquidation value of the company is 400 crore. So all the secured creditors, they will receive the amount which is equal to their liquidation value, and the balance of their outstanding, that will be considered as unsecured, creditor, unsecured debt. And that unsecured debt along with the other unsecured financial creditors, along with the other operational creditor, that will be, they all will be entitled to the balance amount. Now, I'm only apprehensive that in this process, the registered valuer actually will become a very, very important process. Getting a valuation done, getting the liquidation value of the company. Although this is now made it very clear that the liquidation value would be part of the information memorandum, so that everyone should know what is the liquidation value of the assets of the company. So what I'm trying to say is that in case of a secured financial creditor who has a property worth 12 crores, and somehow the registered valuers have valued it only at 6 crores. So as per the law, the secured financial creditor will only will only get 6 crores in the resolution plan. However, he will prefer the liquidation, because in the liquidation, he will have the right to invoke Section 52 and will be able to realize the proceeds of the secured asset. However, in case of any asset where the registered value for suppose a working capital lenders, most of the current assets would not find much value in the registered valuer's report. So they actually will be almost become unsecured financial creditor, and their claim would actually be merged with, their claim will be pari passu with the other unsecured financial creditors, operational creditors, including the government dues. So this is not really acceptable that the secured creditors in a resolution plan will be offered only the value of their liquidation value, the amount which is equal to their liquidation value. So in that means the most of the working capital lenders will be suffering, and all those people where the valuation is incorrect, either they will gain or they will lose. So the valuation process will be a very, very kind of stressful process to get the assets of the company valued. So in this COC, a lot more discussions will be seen between the creditors and between the valuers, and everyone will try to get their assets valued at a higher price. So liquidation value of the companies is likely to go up. Liquidation value of the companies is likely to go up, and the registered values will come under a lot of pressure from the creditors. So Ankit, what do you think about this? This is what I have understood from this amendment. And before I go to the challenge mechanism, this is required to be deliberated, that the first liquidation value, because this is not applicable in liquidation. In liquidation, the amendment is slightly different. In liquidation, the first right is for all the secured creditors. In liquidation, this law is not applicable. It is only proposed for the resolution. In liquidation, the proposal is that first the entire asset, whatever is realized, that will be distributed to the secured creditors. And in case anything is left, then of course the workmen and the employees will be handled. After that, whatever is left, then the unsecured part, and the remaining part of the secured creditor, remaining all will be at par. Means unsecured financial creditors, government authorities, and the operational creditor will be at par. This is the kind of amendment that they're now proposing in liquidation process. However, in the resolution process, the distribution of the proceeds are like this. So there are two separate processes are being proposed.
So basically, I think that the idea is that in case of a CRP process, let's say a company has a total liquidation value of 50 crores and the resolution plan comes in for 60 crores. Now, if I think that maybe we need to understand more about what is the thought process there and how this actual regulation will come in. So the idea is that wherever the 50 crore assets are that value is supposed to be bifurcated based on the security availability with each of the creditors. And if there is any remaining value out of those assets or the liquidation value, then that is distributed between all the creditors. So in case 50 crores, 10 crores comes extra, then 10 crores is distributed across the OCs as well as the FCs and everyone, including the income tax authority also.
No,
So
it's very,
whatever is coming in additionally over and above the liquidation value is distributed to everyone.
no, I think the difference, I could see the difference. The difference is that in a resolution plan, the remaining part of the secured creditors and the remaining part of the unsecured financial creditors and the government authorities and the operational creditors will become pari passu.
Yes.
However, in the liquidation process, it is not the way which has been proposed. In liquidation process, what is proposed is that the assets will be distributed to the secured creditors. And when all the secured creditors are paid off, then the remaining amount, they are keeping the rights of the workmen and employees all without any change. But after this, whatever amount is left, that will be distributed amongst the unsecured financial creditors, government authorities, and operational creditors. So the basic difference is in a resolution process, the anything over and above the liquidation value, anything over and above the liquidation value of each secured creditor, that also gets merged with the unsecured creditors. However, in the liquidation, this is not proposed. In liquidation, first of all, the entire secured creditors will be paid, and then only it goes to the down the waterfall arrangement. So this is a slight change. However, in this process, the liquidation value has become very, very important. Anyway, we go forward, and this is the challenge mechanism. So they are trying to make it mandatory. So we are okay with this, the challenge mechanism. In fact, to mitigate such delays and value destruction, it is being considered that the COC may mandated and transparently consider competing plans through an appropriately designed challenge mechanism. This is absolutely fine. Monitoring the implementation of the plan. So presently, there was no provisions in the code which will actually which will be used for the implementation of the resolution plan. Now, what are being proposed in the proposed framework is the constitution of monitoring committee to oversee the implementation of the resolution plan. The mechanism may prove helpful in providing information about the status of the implementation of the resolution plan and introducing the mechanism for fixing accountability. The accountability of the monitoring committee also would be fixed. So it is being considered that section 30 may be amended to provide the committee of creditors may provide for constitution of monitoring committee for monitoring and supervising the implementation of the resolution plans after its approval by the adjudicating authority. So the present framework is that the monitoring committee would be part of the resolution plan. It will be proposed by the resolution applicant, but now in this proposed amendment, the monitoring committee would be proposed by the committee of creditors, and even the duties and the obligations and also the responsibility will be fixed on the monitoring committee. I think that's good.
So because the RA was earlier proposing a monitoring committee, and that was maybe subject to discussion also. But now with this change, the RA would lose their right to appoint a monitoring committee. The COC will get that power. So it's a good change.
Yeah. Now, opportunity to cure the defects in the resolution plan, I think this is also a kind of welcome. However, the process would be further delayed. The adjudicating authority will make maybe multiple efforts to still get the resolution plan approved. It can be sent to the committee of creditors for any removal of the defects. So, then everyone will understand that any defect left in the resolution plan will not lead the company to liquidation. So there may be some kind of casual approach seen while approving the resolution plans, and let it be seen by the adjudicating authority and let it come back to COC. That kind of attitude might even get developed in the profession, and the adjudicating authority may have 2 or 3 rounds of the committee of creditors, and then adjudicating authority, then committee of creditors, then adjudicating authority. However, but then it is still better than letting the company go to liquidation. Reinstating CIRP, this is again maybe since
Interesting concept, yeah.
yeah,
So it talks about how a company which is a going concern or still the business is running under liquidation can where how CRP can be revived on the consent of the COC and then approval of the adjudicating authority. So it's bringing the company back from liquidation to CIRP and then finding a resolution, because I think the feedback that went to the IBBI and the government was that once a going concern goes into liquidation, then selling that business as a going concern becomes very, very difficult. So they have created this framework for a CRP to be done for a going concern under liquidation, especially where there is a change in the market, change in the process. So maybe one or two cases where the ED was, that was a special circumstance. Many of our cases where ED was enforcing its rights, now ED's enforcement is gone. So therefore the asset, the CRP can be revived and the CRP can be processed. So other examples are also there where maybe
I
some
think
other
Ankit,
difficulty.
this may be a replacement of selling the company as a going concern in liquidation process, because that's a half law. So
Yeah,
they finally, when this particular modification would be done, then I think then the liquidation as a going concern regulation will be completely omitted. So this will be the only process. I think this is a replacement of liquidation as a going concern. This is what I guesstimate. I think
possible.
we can move forward and reinstating CIRP, that we've already discussed that this is the way that the CIRP can be reinstated. So there are two ways that the CIRP can reinstate it now. One in case the company goes into liquidation and still is being kept as a going concern, and still the COC or the SEC finds it that the company can be revived and the CIRP can be restarted by the adjudicating authority. That is the number one, reinstating CIRP. Second is when this when this resolution plan is approved and the resolution plan is contravened, then again the adjudicating authority has two options. One is to liquidate the company or to reinstate the resolution CIRP on the recommendation of the committee of creditors. So there are two ways the CIRP can be reinstated. One, even after the resolution plan is approved first time, and the second time also after its contravention, again the reinstating of CIRP, and the second is during liquidation. That's what is the proposal. I think this is a good proposal. I think going ahead, we have the intermingling of the assets of the committee of creditor and its grunters. We have seen in many cases, based on some judicial pronouncement, the assets owned by the grunters, which are intermingled with the assets of the corporate debtor, those are now it is being validated by the amendment in the code, and the proposed amendment is that the in case of any asset which is owned by any guarantor and mortgage to the bank, then the financial creditors can take a decision to sell it through the CIRP process. But when they do that, they will have to go through all the provisions of SARFAESI Act, like giving 13(2) notice, giving 13(4) notice, giving them the sale notice for the 30 days. All those processes will have to be conducted. Then only it will become viable to sell that particular asset along with the company in the CIRP process. I think, Ankit, this is a welcome process, because the SARFAESI law is also being protected, their rights are also being protected, and the value also will actually be enhanced. Value would be enhanced.
We tried we had tried consecutive use of SARFAESI and IBC in a few cases. This will give teeth to the whole law so that simultaneous action can be done as per law.
We've been doing in some cases where the simultaneously SARFAESI and the insolvency
coordination, which sometimes the coordination was practically difficult for both the processes to be completed. There was discomfort from the buyer sometimes. I think this will add confidence.
Another proposal is that the interdependent entities, this is a kind of
group insolvency has been
domestic group insolvency that they are proposing.
Yes.
However, the IBBI will specify the procedures, and in such cases, in case the adjudicating authority and the common IP would be engaged, and the CDs are also
the videocon judgment has been kind of adopted, I guess, that yes,
yes.
that can be adopted in some special circumstances.
In case it comes in the law, it will actually help.
Yes.
So this is the other amendment that we wanted to discuss, because in this case, the proposal is that all unsecured all unsecured creditors, financial creditors, operational creditor, and government or authority other than workmen and employees shall be treated equally for distribution under Section 53. The order of priority for the secured creditors, workmen, and employees shall be retained as stipulated under Section 53. So there is a difference in this amendment and the amendment for distribution of proceeds under resolution plan. In this amendment under Section 53, the first right will remain with all the secured creditors, and when they are fully paid, then the balance will be distributed to unsecured creditors, unsecured financial creditors, and the operational creditors and the government dues. So I could
This is what was proposed there also. But what I'm trying to say is that I think the only clarity that is required is that like I think this will also create the fact that secured creditors should be secured to the extent of their security interest. Is that clarified? I was not able to see that. If that is clarified,
that is not there in this proposal.
that needs clarification, that in case you say that the secured creditor is secure to the extent of its security and other part of the secured creditor will be treated as unsecured, then it will be a uniform process in liquidation and CIRP. And that would make sense also. And then we have been talking about how having a security, having a first charge should actually have a first role.
So Ankit, this is also like kind of the State Tax Officer versus Rainbow Papers Limited. Again, this dilution of this judgment, where the definition of security interest, it was thought that the Supreme Court has said that the creation of security interest is automatic. However, this proposed amendment is making it very clear that the definition of transaction under Section 3, subsection 33, there has to be a transaction, which includes an agreement or arrangement in writing to transfer the assets. So in case there is no transfer, then the security interest would not be created. It will not be automatic. Now, I am not very clear whether this the attachment, which is the suo motu attachment, or which is the attachment just by the action of a government officer, whether that becomes a transaction or not. See, anything which is not attached is something which is very clear. However, if the attachment is done, whether the attachment would be considered as a transaction, that needs a clarification.
So I think that's more to do with how maybe let me try and give an example. Let's say the state government or any of its agencies kinds of enters into a purchase transaction or a vendor transaction with the company, and there it says that okay, we are creating a security interest till the time this contract or this process is complete. So I think that would be a transaction. Then there can be a transaction for some land that is given by the central government or the state government to the CD. I think that would amount to a transaction. Simply liability on account of any tax will not become a transaction.
So that means like all the State Industrial Development Corporation, in their agreement of allotment, they already have a provision that against the dues of the corporation, they will have the lien on the property. Similarly, in the electricity departments of various states, they have an agreement. In the agreement, it is always stated that the state electricity department will have lien on the property of the user. So these are the transactions, and they will be considered as secured operational creditor. However, the attachment as such would not be considered as a transaction, because it's very clear the transaction means an agreement or arrangement in writing. Attachment cannot be in writing.
Yeah.
So I think this is the clarity in treatment of security interest created by statute. That's what we've already discussed. Rainbow paper mill diluted. The valuation estimate would be provided in the information memorandum.
Change. This is a big change where so far the valuation was supposed to be kept in the pocket and kept as a secret. Now it will be part open in the IM. So it will help, because when we see the process from the other side, from the RA's perspective, the RA is normally clueless as to what kind of value are they expecting. So some kind of feedback on at least maybe a reserve price, maybe the liquidation value in the market will perhaps provide more confidence to the market, allow the right people to come in. RAs would know whether the assets are valued at 10 crores or 10 lakhs or 100 crores. Then they can decide accordingly to whether that interests them or not. Maybe a good idea.
But this is also important that so far, whatever wording has been used, it has been used that the information memorandum shall contain an estimation of the valuation of the corporate debtors' assets. So simply, they are not saying that you provide the liquidation value. They are saying the estimation of the valuation of the corporate debtors' assets. So that actually means
the fair value.
Not only this, that actually means that the asset-wise valuation can be provided in the IM, not only the liquidation value of the company. So that's also, in fact, a very good, because everyone will know, the dissenting creditors will know what is the
Fair
liquidation
value,
value of their
basically.
assets.
Yeah, fair
So
value,
that
basically.
actually
Yeah.
will be very good. Now, the certain categories of the operational creditors to honor the agreement with the CD for the remaining useful life of the agreement. This is basically an amendment in section 14, which is a section for moratorium, and some of the rights, grants, which the central government or the operational creditors. So that is now kind of, it is already there through the judicial pronouncements, but this actually will add to the law that actually will be good. Protecting the resolution applicant post implementation of the resolution plan concerning civil liabilities.
The
That is also
reinforcement
kind of
of the,
clean,
yeah,
it is a
Hydra head
Yes,
reinforcement,
this
that
is
you can't have things
a
popping up.
reinforcement of the same. The computation of voting share in some cases, this is very important. Section 578, because in some cases, when we see that a lot of operational creditors are there and there is no financial creditor, we have seen that many people, they don't participate into the COC process because they feel that in case they will participate, they'll have to share the CIRP cost. So they don't participate. So in this case, now some relaxation has been given, that the voting share will be calculated based on the people attending and voting. And however, the 51% has to be assured still. But in any case where the less than 50%, 51% still there, then again the adjudicating authority would be the only kind of saving platform where you can actually approach. So this is also a good one. Incentivizes anyone who actually provides interim finance, they will actually have a
See
right to
meetings.
participate
Yeah.
into the COC meeting without any voting.
But they've still not addressed the interim finance issue with respect to limitation of that period of that interest. I think that
Yes.
is something that was a bigger problem based on our understanding.
Yeah. This section 241, subsection 2 of the Companies Act, which actually empowers central government to apply to NCLT for appropriate relief against oppressions and mismanagement if it is believed that the affairs of the company are being conducted in a manner prejudicial to the public interest. So in this particular scenario, now this particular kind of powers are also will be inserted in IBC, where the entire process will be conducted under the IBC, and the administrator would be appointed by the central government, especially in those cases which actually involve public interest. However, all the duties of the insolvency professionals, IRP, RP, or liquidator will continue. The only one thing will be changed, that this particular person, the administrator, would not be replaceable. The COC will conduct the process, but the administrator will not be replaced. So this is also a good option which the government has taken with itself for all those companies where the public interest can be seen for those companies. So
Question is that, yeah, the larger cases, the government wants to play a role where they want to be part of the process and kind of make sure that everything is going right, or rather have an eye in the COC. Good step.
Now, in this amendment, where the section 462 of the Companies Act empowers central government to exempt a class or class of companies from applicability some provisions of the Act. Similarly, the insolvency law would also be having a provision where the government can think at a particular point of time that for a period of this much, the insolvency law would not be applicable to such class of companies. So I think this can be used.
Government, they will be using this for government companies, I guess. That's
No,
the intent.
not for the government company, but they can actually use it for a particular class of companies. Like, for example, some kind of bad scene is going on. Maybe in COVID scenario, this could have been one option to exempt hotels in that period, because the hotels would have come under stress. Similarly, in case of like everyone knows that the thermal power plants are not presently a viable process, so they can say that for thermal power plants, the insolvency would not be applicable. So these kind of, or they can even say that any company where the RERA has taken action, the insolvency cannot be started. So these kind of class of creditors
It will also be spread to government companies.
Yeah.
I think so, yeah.
See, in the individual insolvency, there are very, very welcome kind of amendments. One, that the moratorium simply on filing an application has been deleted, that there will not be any moratorium on simply filing an application under Section 96 protecting the personal guarantors. Then the there is a recommendation that the RP for the company and RP for the personal guarantor should be the same. And also the meeting of the creditors is compulsory, even if the resolution plan, even if the repayment plan is not submitted. Then in that case, the resolution professional will submit a report, and then the adjudicating authority, and then the creditors may take they may take a decision to start the bankruptcy of the debtor. And the fraudulent transactions were not there in the provision, so there will be a new provision which will actually attend to the fraudulent transactions. And the avoidance transaction section 101 to 124 may be amended to provide that avoidance transaction proceedings pursuant to any CIRP may be exempted from the moratorium. Since the moratorium was applicable to personal guarantors, and on the meantime, the avoidance transaction proceedings were going against them. So they were taking this plea that since I'm under moratorium, no proceeding can continue. So those transactions will get exemption. Recasting of the liquidation process very quickly, we can handle the direct dissolution. Even in some cases we have seen, but now the committee of creditors can recommend direct dissolution immediately after the CIRP when they see that there is no asset or there is no something which can be revived. Eliminating duplication of various efforts like claim verification during CIRP and the liquidation process, that's already there. The verification is already there. The role of the creditors is already there as per the regulation, but this is being now added through the IBC, but this is already there. Because these are the amendment, the replacement of the liquidator is already there, but this is being added in the IBC, replacement of the liquidator. Similarly, and this is also good amendment, and the liquidation process, all the proceedings were continued, but now those also will continue to stay. So this will help in closing the liquidation processes a little faster. That actually is a very, very important amendment. Realization of security interest by the secured creditor. I think this is also there in the regulation, that in case the secured creditor doesn't inform or doesn't choose within a stipulated period, it will be considered as relinquished. Similarly, in the case of multiple
also clarified that they will decide.
It's only clarification. They have to decide, and unless all decide to not to relinquish, it will be considered as relinquished. So a role of the service provider, I think they have also now, there are two things which is very important for all our professional friends, that earlier there was IBBI can take show cause notice. Similarly, the valuers are also coming under the regulation of the IBBI for the purpose of issuing SCN and for the purpose of taking action against them. So this is the kind
they've also talked about building a panel for valuers. So I think there might be another intention that once the valuers move out to maybe a separate segment or a separate regulator, if that happens, then IBBI will continue to have a panel of valuers impaneled with it. Okay, so they've also talked about in the last slide. So I think there are some questions. Should we take them quickly?
No, I think this time is already there, because if we already have 1 hour 23 minutes, so which is already very high. But then, yes, we can
maybe
we can take for another 7 minutes. Let's make it as 1.5 hours.
So if distribution will be separated, will it pose further challenge for the RP, as in resolution plan approved by RP, both are approved? No, the resolution plan will be approved separately. The distribution plan will be approved separately. That is what we think will happen, right?
Absolutely. This is what is proposed.
So then we are talking about whether the FC whose security interest was defined by way of charge registered would be rendered helpless by entry of statutory dues pertaining surprising as holding first charge, pushing back the FCs. Is it not violation of natural justice? So I think we have talked about this, that only the transactional data will be there.
The transactional data is restricted to something which is arrangement in writing, not a kind of one-sided action by any government department. However, the arrangement in writing that actually will be applicable to the landowners, the industrial development corporations of the states, electricity department. So these are all the arrangements are in writing. So
let's see more details. I think based on the current idea, this is what we understand. Ranjan Chakrabarti is asking, IU's rule will increase to lessen the delay. Can anyone dispute IU? So yes, IU, if it's IU is only an intermediary. So IU will basically is a technology platform where an FC or an OC will say that, okay, this is my claim against this person. That person will counter that claim if that is wrong, and the IU will make a final decision. So in case the idea is that where there has been no reply, where the corporate debtor has not made any reply and he has been given that opportunity, then he can't go to NCLT and say that, oh, this is disputed, because IU has already tried and kind of sorted that dispute or asked for the dispute. That I think is the intention, that using technology to understand if there is a dispute, and then if there was no dispute at that point in time, then later one can't say that there is a dispute.
Yeah.
What will be the difference between voluntary winding up and PPARP in terms of paying OC? I
No,
don't
I think
think.
with voluntary winding up, we have to ensure that 100%
Yeah, voluntary
debts are
winding.
being paid. However, in this case, whatever,
PPARP, there will be a haircut almost always in a PPARP. In a
yes,
voluntary winding up, everyone will get paid. There can't be an insolvency there.
yeah,
The proposal is differentiating between projects and home buyers according to the stage of construction. Is it tenable? Not the stage of construction exactly. It is actually differentiating between the viable projects and the unviable projects. So in case a project is unviable, then that unviable project will be segregated and put into insolvency.
not
Viable
default, project in default,
Project in
project
default,
in
yeah.
default,
The
project
project
in
in default.
default.
My bad,
Yeah.
not viable. Project in default. So the ones which are viable will most probably not be in default at all, like normally, in case that is how it is working. How about settlement of OCs dues who are common for the entire CD rather than project specific ones in real estate CD? The OCs will have to establish that they are creditors to the project specific work that they have done. That's what I can imagine.
But that's what I said, that there are practical difficulties
Yeah,
for
these.
the project-wise solution for real estate companies will have a lot of practical difficulties regarding common creditors. So that's a very big difficulty. I think the IBBI will come out with some further clarifications by way of regulations.
How is loss measurable in section 235A? Loss is measurable by a
Loss
many,
measurable is again, I think the adjudicating authority will say, and
yes.
also it will be up to the
Lawyers will make
applicant
a
and up to the
claim,
respondent.
RP will make a claim, RA will make a claim that I have suffered this loss because of this delay caused by frivolous litigation, maybe. When the liquidation value is known to the RAs, the resolution plan outflow would tend to be hovering around liquidation value unless, I think we have talked about this, that in the
We have to
IM we are
assure
talking,
completion.
yeah,
We have to assure
IM we're
completion.
talking about valuation, not the liquidation value. So fair value will perhaps be more. So that is the idea here. This is what we could understand. Sometimes the email ID is given by FCs is wrong, making authentication of information in IO impossible. Even RPADs fall in such case. Authentication is not categorized. So how will it be treated?
These are the exact kind of litigation that I foresee, that the authentication of the IU's process also would be challenged.
No, so
And
my thought process is, in case you talk about an IU and say the IU is linked to the MCA data. Now, in case you have in your MCA data for a company, you have provided an email ID. It is the company's duty to make sure that that ID is working, that ID is available in public. So I think that this kind of due diligence, that okay, what is your official email ID on the MCA website, is an important idea. Similarly, directors' email addresses are available on the MCA data. They should be accurate ones, or the ones that the FC is getting. Otherwise, in future, when you raise a dispute and say, I never got the email, then the people will say that or claim that we sent it to your official ID. How are we wrong? So I think that needs to be corrected practically. I think same treatment to statute dues too. This may be defined post new years. I don't know. This one will. So in case of separation of distribution proceeds equal to liquidation value, balance amount is to be treated as unsecured lenders. I think we need more clarity on that one also. So let's see. We have already shared our thoughts on it. If the AA does not have discretion, then why judicial members should? I think again. So the discretion that we're talking about in NCLT to admit the matter or not admit the matter is basically with respect to discretion uh, on the pending default, or discretion on whether the amount is if there is a default or not. So that determination is still the discretion of NCLT. It's not that they are just the registry should say that, okay, let's put this company into insolvency because there's a default.
Reasons for the default is not the jurisdiction of
yeah, that's the differentiation.
that's what
But
is the
whether there is a
adjudicating
default or
power.
not is still requiring the judge's attention and the judge's
The
thought process.
adjudicating authority is not given a power to find out the reasons for the default. If the reasons are somehow reversible in the near future, they cannot say that this is not a fit case for insolvency.
So thank you, everyone. I think we have taken up most questions.
I think the most important understanding that I would like to see everyone should deliberate is what is the distribution process for the resolution plans and what are the changes in section 53 for the liquidation purposes. What I understand is for the liquidation purposes, the rights of the secured creditors are not impacted. It is only the rights of the unsecured financial creditors are merged with the with the operational creditors and the government authorities. It is only the rights of unsecured financial creditors are slightly compromised. However, in the distribution process in a resolution plan, the rights of the secured creditors are also compromised. And first, they will get the value of their security interest based on the liquidation value, not on the fair value. This is where I find some difficulty, because this will make the process of registered valuers and getting a valuation of the assets done, that actually will become, and that will take a lot of time in a resolution process. However, once their security interest is realized, which is the option available with them under SARFAESI Act, whatever comes balance, then the balance will be allocated between their remaining portion, unsecured financial creditors, government authorities, and operational creditors in the ratio of their outstanding debt. This is what is my understanding. And in case there is anything that you find that my understanding is incorrect, kindly SMS me, kindly WhatsApp me. We will have a discussion. Thank you very much. Thanks a lot. And it is a pleasure to see such a great response of this webinar, because I think everyone was looking forward to on deliberations on this proposed amendment. Once this amendment becomes act, again, we will come up with the final outcome, whatever it comes. But I would request everyone that you must give your suggestions by 7th of February 2023 on the website of IBBI. Thank you very much.
Thank you, everyone. Thank you.